And we always have time for one more interview. Now, banks and other credit providers are no longer forced to delete the details of people who try to defraud them. Yesterday, the court dismissed an appeal application by the National Credit Regulator seeking that the service providers remove the names a year after being listed. And companies share these reports through the Southern African Fraud Prevention Service, which only removes them after 10 years. And the organization keeps track of those who attempt identity fraud, who use forged documents, or who just been turned down when they are suspected of committing fraud. The Executive Director of the SA Fraud Prevention Service, Manie Van Schalkwyk, is with us this morning to tell us more about this. Manie, good to see you again.
Good morning.
So, for the benefit of our viewers, if you could just give us a brief background to this particular case.
Yes, and maybe start with what we do. We are a non-profit organization which keeps confirmed fraud information. So if you want to steal somebody else's ID, or you are lying about your payslip, or you manufacture bank statements, etc., you will be finding yourself listed on this database, and we keep the information for 10 years. Another big part of our business is we provide a free service to consumers who are victims of identity fraud. And also, if you lose your ID or it's compromised, you can get yourself listed free of charge as a protective registration. So we keep this information for 10 years. And that became the issue of dispute, is that the National Credit Regulator thought or interpreted the Act that the negative credit information is similar to fraud information. And therefore, they said, because of that fact, we can only keep the information for 1 year. And our data shows that these fraudsters come back into the system up to a maximum of 10 years. So that's why we kept the data for 10 years. And that was then taken to the High Court about 18 months ago. We won that case, and then they appealed that case to the Supreme Court of Appeals about 2 or 3 weeks ago, and we got the judgment that we won the case again.
So one of the contentious issues for me reading through this was that you also put those who are suspected of committing fraud. So when the suspicion exists, explain that to us.
Yeah, there's a very small part, and that information is only kept for 3 months. But the majority and the crux of the data of about 80,000 records are about people who fraud was suspected, and then the organization, the banks or the retailers, put a forensic team behind it, and then they've got proof. As soon as they've got the proof that this fraud exists, then they'll only list it on our database.
So part of the argument by the credit regulator was that 10 years is a long time, perhaps too long.
Yeah.
There's even talk of maybe people committed, an error. Maybe it was a mistake. What's your take on that?
Yeah, I think two things, and remind me if I forget about the error. But the first thing, I think, it came out in the judgment very clearly, where the judge said, if somebody has lost their job and they can't find another job and they get themselves insolvent, declared insolvent, they find more money and they rehabilitate themselves, that individual will be on the credit bureau for 10 years. So if you look at the ultimate sin of somebody who's lying, deceiving, stealing somebody else's ID, misrepresenting themselves, never with the intention to repay, that must be removed after 1 year. The court said this does not make any sense, and is devoid of any sense. So that is important to understand and put it in context, that you cannot have the ultimate sinner removed after 1 year, where the guy that couldn't afford the credit is on for 10 years. Then I think you made the point about if you are there incorrectly, and it happens. So somebody will steal your ID, and they will open an account at Edgar's. Edgar's will try to phone you eventually and say, why don't you repay us? And when they do an investigation, they say, oh, there's fraud. And then you get listed on our database. So you should not be there. And that is where we have got a proper dispute mechanism in place, where we will take you through a process. We will connect you with people at Edgar's. They will do the investigation, and then they will realize you are the victim of fraud. And that's when you will get listed on a victim database, which we will then assist you in providing additional protection going forward to make sure that your information is not used in fraudulent transactions.
You know what, Manie, we're out of time, but we're going to try and bring you back to talk about this issue of identity fraud, because it becomes so difficult to even prove that you are a victim of identity fraud, never mind, being rehabilitated and getting your name removed from these various databases. So hopefully we'll be able to get you back to talk about that.
That will be wonderful.
Absolutely. Thank you so much to Manie Van Schalkwyk, Executive Director of the Southern African Fraud Prevention Service, for talking to us about yesterday's court ruling that allows credit providers to keep the details of fraudsters on their database